Justices.
I think that you don't want to give them any more time, do you? It's fine.
Yeah, no,
You okay?
Yep, that's all right, I think.
Right. Thank you very, very much. But in reply, please remember to talk about the Constitution if you'd like. Okay. Thank you very much for that. I think that we've all been very much educated. Now, Counsel for the Respondent, are you ready to argue this, oppose this scintillating argument?
Yes, Justice.
Please go ahead.
May it please the Court. This matter concerns an appeal against the decision of the Durban High Court, which awarded Andile Langa, the respondent, or the massive profits resulting from the University of Impangeni's, the appellant, creation of the Schleller cell line, which was derived from the respondent's mother's deceased body. We submit, that the court's ACO was correct. Greed cannot be condoned, and neither should Mr. Langa's inheritance be robbed.
That's quite a strong statement. Why would you say greed?
Greed.
Yes, we've heard your learned friends argue that the funds or the monies that were derived from the research and use of the deceased cells were used to give back to the community and for medical research. Does that translate to greed?
Justice, I submit that could translate to greed because the appellants used it for private gain and for their own personal benefits. It wasn't stated in the facts that they benefited the entire community. The profits should have gone to Mr. Langa as his mother was the material cause and the material reason of the creation of the Schleller cell line.
So that he could profit from the use of his mother's cells?
Essentially, yes, Justice, because he is the descendant and entitled to the benefits as the deceased, as the descendant of the deceased. Why we believe that the Court ACO was correct in its decision, we will show this by firstly establishing that Ms. Langa was the proper owner of the biopsy sample.
But isn't this the question of a child wanting to benefit from his mother's death? Isn't that all it is?
Justice.
Is that a good thing?
Justice, it would not be a good thing. However...
is that a good thing?
No, Justice.
Right, so now please try and come around that argument. Here's a little boy, young kid, who instead of working for himself, prides himself in making the money at the expense of his mother's death of cancer.
Justice, the son is the rightful descendant of Ms. Langa, and it would not be a right thing. However, Mr. Langa and Ms. Langa, it could be said that they came from a disadvantaged background, as in the facts it is stated that they were from the outskirts of Impangeni. Therefore, these profits would further them as individuals. And essentially, the profits would be used to further themselves.
But are we going to encourage self-selfishness in our society?
No, Justice.
So shouldn't you lose your case then?
Justice, we believe that, we submit rather that Ms. Langa was the material reason of this Schleller cell line, and in society we need to be able to further people from disadvantaged backgrounds.
How old is your client, by the way? What's he doing? He must be begging somewhere or something.
Sorry, Justice, I didn't
What does
quite...
your client do? How old is he?
He's
What does he do
an
for a
adult.
living?
Yeah.
This was not essentially stated
Sorry.
in the facts. There wasn't any conclusive evidence as to what he does for a living.
May I inquire of you this? Does the respondent contend that if the deceased had known what her cells would be used for, she would not have consented. And the fact that she did consent and that the university then derived an income from it is not something she would have approved of.
Justice, we submit that...
Let me summarize my question. Let us hear your submissions on consent.
Justice, we submit that we had erred on the form of consent, and we would concede this matter as we did not see any conclusive evidence from the facts as to the surroundings of the respondent as well as Ms. Langa.
Is that not the end of your case then? If you're
No,
conceding that there was consent, is that not the end of your case?
No, Justice, it would not be the end of our case because we believe that Ms. Langa was the rightful owner and that ownership still vested in her and therefore her son as the descendant.
Did you consent to allowing them to make profits? Where does that come? I didn't see that anywhere. Maybe your concession is going too far. If your client had been told, if your client's mother had been told that, you know, we might make, and the document had said, even if the university makes 100 million out of the tissue that we take from you, you or your children will have no rights. And she was told that. What would she have said?
Justice, we submit that Ms. Langa, well, we don't have any conclusive evidence. However, we submit that Ms. Langa would essentially not have consented to such.
Well, your number 2 of your heads of argument, what does that argument say? What is your argument there?
Justice, we essentially concede on this matter of informed consent as we had made deductions from facts that were not exclusively stated in the facts that we were given.
But are you conceding there was an informed consent?
Yes, Justice.
Why are you doing that if here you say that she didn't consent to commercialize? She consented to the commercial research, but did she consent to them making profits out of it?
No, Justice, she didn't.
So why are you then conceding?
Justice, that is an error on my part.
Okay.
My trouble is, even if she didn't consent properly, what gives her son the right to the money?
Yeah.
Justice, he is the rightful descendant of Ms. Langa.
We don't know. Did she make a will in his favor or something?
No, however,
Have you seen the will?
Justice, no, we have not seen the will
The
of the
fact
will.
that he's just her son doesn't really matter. He may have been miserable to her.
That
She
is
may have
an-
wanted to disinherit him. How do we know?
That is indeed true, Justice. However, one could look at the law of succession and interstate succession, where it is stated that upon a deceased's death, their assets would essentially fall into their estate, and therefore the deceased family would become the beneficiaries of that estate and therefore entitled to the deceased person's estate.
Okay.
Is that the best you can do?
So it might have to be referred back to the court below to get that evidence.
Maybe, yeah.
Okay, carry on.
Continue.
Justices, in paragraph 20 of our heads of argument, we state that the National Health Act and its regulations have created a new mode of original acquisition of ownership in human biological material through its inclusion of the term donation. Donation isn't essentially defined in the Act or the regulations. However, one may say that donation occurs where a person gives and transfers their property to another person without expecting a reward in return. Therefore, the inclusion of the term donation would provide that human biological material is susceptible to ownership, and the research participant is automatically considered the owner of the human biological material taken from their body, which was intended for research, as they would be transferring their human biological material to the research institution. Therefore,
sorry, in all of this I didn't catch your name. What is it again?
Ms. Tanatswa Chinyanga.
Yes. You've referred us to the National Health Act. Does that not conflict with Section 12 of the Constitution, which you've referred to at paragraph 10 of your heads? And should you not challenge that provision?
Justice, may I ask?
So my point is this. The NHA allows for ownership to pass, ownership of human tissue to pass onto a third party. But in this case, you've got Section 12, which says that everyone has the right to bodily and psychological integrity, which includes the right not to be subject to medical or scientific experiments without their informed consent.
Yes, Justice. The National Health Act, so essentially the Constitution would take precedent as it is the supreme law of the land. However, the National Health Act does give specific purposes in which donations and transfer of ownership can occur, and these coincide with the constitutional provision to protect the participants in the research projects.
Is there a difference? Sorry. Is there a difference between sharing gains and giving your gains away?
Justice, I do not believe there is a difference.
All right, don't worry.
Well, it comes down to the point of benefit sharing, isn't
Yeah.
it?
It does. It comes down to benefit sharing, and does the Act say you can't give the benefits away? You've got to keep them for yourself? Does the Act say that? Or does it say you can't keep part and give someone else part?
Justice, this matter will be dealt with by my co-counsel.
We eagerly await her submissions.
Justices, the counsels for the appellant are indeed correct in paragraph 28, page 9 of their heads of argument, and their reference to the general control regulations, in stating that a tissue may be donated to a university in terms of Regulation 4, subsection A, and further that in terms of Regulation 26, that any institution that acquires tissue in accordance with the provision of the Act or subsidiary regulations shall, provided that the tissue is used for the purposes for which it was donated, shall upon receipt of the tissue acquire exclusive rights in respect thereof. However, we submit that although this is correct, our learned colleagues did not give consideration to Section 64 of the National Health Act, which provides the specific purposes in which a donation may be made. And these purposes include the training of students, health research, advancement of health sciences, therapeutic purposes, and the production of therapeutic, diagnostic, or prophylactic substances. Regulation 7 also states the purposes of a donation and states that an institution to whom scientific tissue has been supplied may use the tissue only for the purposes stated in Section 64. Therefore, the research institution, the appellant, could only acquire exclusive rights over the donated sample if they were using it for one of the purposes stated in Section 64. By the appellant using this biopsy sample to create a separate cell line and to sell it internationally and locally to make huge profits for themselves, it is evidently seen that they have not acted in accordance to one of the purposes of Section 64, as nowhere in this Act or in this section specifically does it include or permit the use of donated tissue to generate profits for private gain.
But to penalize the appellant by claiming all their profits, is that salutary? Is that appropriate? Is that an appropriate sanction for contravening that provision of the Act?
Justice, we submit that it would be appropriate in this case specifically because the research institution is a world-renowned institution as stated in the facts. Therefore, they should have known and been well aware of these certain provisions in the National Health Act and should have taken the necessary steps to ensure that they adhere to this act.
How much more time do you need?
We're not giving you your freedom yet.
Let's keep it to what you have to say. But how much more time do you need?
Maybe 5 more minutes, Justices.
That's a lot. Let's make it.
All right, Justice. Therefore, we submit that since the appellants do not use the sample in terms of the purposes stated in the Act in terms of Regulation 26, they did not acquire exclusive rights of ownership over the sample and thus did not own the Schleller cell line derived. Further, the appellants argue that should their points be flawed, which we have shown it was, they would rely on the common law principle of specificatio. However, we submit that this principle cannot in fact be relied upon. According to Thaldo, who analyzed the South African context of the Henrietta Lacks, which was mentioned by our learned colleagues, specificatio rests upon the party that created the new substance on being a bona fide possessor of the original material taken.
I have to interrupt you again. You've heard the appellant's argument on benefit sharing, and you've mentioned now exclusive rights. Did the High Court not err in providing or awarding your client all the profits from the research and development that followed the extraction or donation of the deceased cells?
Justice, we submit that they did not err, as essentially benefit sharing is indeed where profits are shared. However, this case is different in the sense that the respondent, Mr. Andile Langa, is the rightful descendant, and the appellants did not act accordingly in any of the steps that they took in producing this Schleller.
What about his brothers and sisters?
Just as it's not stated in the facts whether they were brothers or sisters in this matter.
So he's entitled to exclusive rights over all profits?
Yes, Justice.
What about the research? What about the research that followed?
The cost of the research.
And the cost of it?
Justice, we submit that he would not essentially be, he would be entitled to the research as he is entitled to the exclusive rights of the Schleller cell line. However, he may do what he wants. Exclusive rights essentially means that he may do as he pleases with this research, and therefore he may...
So he would not only be entitled to monetary compensation, but also intellectual property?
Yes, Justice.
Interesting.
Benefit sharing does...
So you mean he must be able to use the ideas later to make his own money?
Yes, Justice. That would be permitted.
And that would be okay?
So if the university makes money, it's not okay. If your client makes money, it's fine.
Did they not actually change her human tissue by developing that new cell line? So that became their tissue. It was no longer her human tissue.
That is indeed correct, Justice. However, they would only become the owner of this new tissue if they had acted bona fide and they were bona fide possessors of the original sample. However, since they were not, because they did not act accordingly to the purposes of the Act, they were not bona fide possessors, therefore, the ownership of the Schleller cell line would be of Ms. Langa and therefore Mr. Langa.
I understand that there was at least 100 million rand in profit made. How much is your client prepared to accept in full and final settlement?
Justice, our client would accept all the profits as he is
So all or
the
nothing.
owner and entitled to all the profits. Yes, Justice.
All right. Thank you very much. Thank you. Now, what about the second argument? And I still want to hear a little more about the Constitution and fairness. But, yeah.
As it pleases the court.
We'll try not to trouble you too much.
I make no such promise.
May it please the court. Justices, one shouldn't look at Ms. Langa's case in isolation, but rather one should look at Ms. Langa's case in the African and South African context, a context which sees research institutions and pharmaceutical companies exploit research participants for two reasons. Firstly, because research participants do not have enough power in relation to pharmaceutical companies and research institutions. But secondly, our learned colleagues in paragraph 19 of their heads of arguments make reference to research participants as laymen. And this is particularly important because this is exactly how research institutions and pharmaceutical companies view research participants. As people with no scientific knowledge, as people who know nothing about research and all the rights that they're entitled to as a result. And because of this view of research participants, makes them easily vulnerable and susceptible to manipulation and exploitation. And this is something that we cannot allow as a South African court.
Ms. Swana, does this not contradict your learned friend's submissions regarding consent?
To clarify our point, our position, rather, Justice, on the issue of consent, we are conceding to the fact that she consented to academic and commercial research. However, part of that commercial research isn't profiting off of the results of the research. And as my learned colleague has rightly pointed out, if one looks at the purposes for research and the purposes of donation stipulated by the National Health Act correlates with our standing point in terms of informed consent.
What does the National Health Act say about the requirements for an informed consent?
Right, so Justice, in terms of the requirements, in terms of informed consent, part of those requirements are the fact that they should explain the purposes for the research, they should explain the risks and the benefits associated with the research, and in this instance, even though we don't have conclusive proof of exactly what happened, we would then say that the consent given by Ms. Langa was defective in the sense that she did not consent to them commercializing the Hlela cell line and the products generated, but rather she consented to purely academic and commercial research.
But look, if you look at it practically, the university, the medical school were trying to help her and trying to cure her. That didn't work. This money and so on just came by the way, isn't it? They didn't intend to get the money. That was not their aim. So shouldn't your client be grateful that the university did a great deal to help, tried to do a great deal to help his mother, and they should use that money to help other people in your mother's position, in his mother's position.
Right. Two responses to that, Justice. Firstly, you make mention of the fact that Ms. Langa approached the University of Empangeni seeking assistance, and that's the very essence of the defect in her consent. Because she was in a dependent relationship with the University of Empangeni, desperate for treatment, desperate for medical care, because she potentially has cancer, potentially being induced into agreeing into something that she would have ordinarily not have agreed to. But secondly, the University of Empangeni, what determined what happened with the profits was how they acted after conducting the research and finding the discovery or the product that was then useful. What they should have done was contacted Ms. Langa's family. Sorry, Justice.
Go a bit more slowly. What they should have done was...
What the University of Empangeni should have done was to call Ms. Langa's family to then discuss a potential agreement on how to engage in this research and how to share these products.
Is that what you morally think should have happened, or do you have some legal basis for that?
Purely moral. Unfortunately, Justice, the case of benefit sharing, there's no legislative framework that currently exists to regulate it. However, this is why it's important for
Ms.
cases...
Swano, sorry to interrupt, but what about her right to privacy?
What about, sorry, Justice?
Her right to privacy. She may not have wanted to share her condition with anyone else. What then does the medical school do?
That's one of the issues, Justices, because she only agreed to the University of Empangeni handling her biopsy sample and handling the academic and commercial research. When they then decided to profit off of the results of that research, because she didn't consent to that, they have invaded her privacy and involved, for example, pharmaceutical companies, which have now also been involved in the profiting off of the results of this product.
It sounds to me like you're retreating from the concession regarding informed consent.
No, Justice, we're not retreating from the concession. However, we are shaping this argument differently in the sense that the consent that was given was A, defective, but secondly, that it, in relation to the National Health Act and the purposes that they've given of research, commercialization of the product is not included or contemplated in the National Health Act.
Let me help you. You also referred in your heads of argument to the possibility, I think, I'm paraphrasing. There's an indication that Mrs. Langa was from a disadvantaged background and may not have been sufficiently educated about what the extraction or donation of the tissue would entail and what the usage of it would be. Is that still your position?
The concession then, Justice, comes in that part. Because of the lack of conclusive evidence, we cannot 100% say that she was from a disadvantaged background. However, we provide to the court, or we submit to the court, that the argument still stands even if Ms. Langa wasn't from a disadvantaged background or from a disadvantaged community.
So your head 16, you actually say she was vulnerable because she wanted the treatment, but she could only get it if she signed that consent form to say that they can use it for research.
Kindly repeat that, Justice.
You say, first of all, she's vulnerable because she desperately wanted treatment for her cancer. But you're saying that she could only sign that consent form if she agreed to consent to it to be used for research as well.
Can I ask that you paraphrase your question rather, Justice? I'm not sure if I'm understanding correctly.
Yeah. You say that she was vulnerable. Okay, tell us why she was vulnerable.
Because she's in a dependent relationship with the University of Empangeni. By that we mean that she has come to seek assistance with a tumor that she has discovered on her body, and because the research or the health practitioner rather, has stipulated that she potentially has cancer, is now in a dependent relationship because she is desperate for help or for medical treatment as a result of this potential discovery.
And because of that, she then agreed to the other term as well, that they can use it for commercial research.
The issue there, Justice, comes in. Our issue with us saying that she is vulnerable and potentially her consent being defective comes in that the consent given for the academic and commercial research should have been given at a later stage and not at the stage when they were asking for her consent for diagnostic purposes and to actually work on her biopsy sample and to test it for the cancer.
Okay.
So is that not your best point? That really it comes down to the ethics of the time and the timing of the consent?
Yes, Justice. So two arguments that we aim to bring forward. The first being of the consent being defective, and the second that my learned colleague has rightly brought to the court about Ms. Langa owning her human biological material. It's important then at this stage to then discuss what are the consequences that flow from her owning that human biological material. And this is what benefit sharing is, and this is how it comes in this instance.
Are we a court of equity or a court of law?
Court of law which cannot ignore equity and justice. Despite there being no legislative framework that exists currently in terms of benefit sharing, it is important for us to make two clarifications. The first being that benefit sharing is not a commercial transaction. And what we mean by that is Ms. Langa does not intend to sell her human biological material in exchange for money, but rather what benefit sharing is compensating research participants for the assistance and the contribution that they've made to research projects. And at this point, it is important to confront the legislation that our learned colleagues bring forth as being relevant to this discussion, which is Section 60.
They could give her the money, him the money, in expression of the gratitude and sympathy for him and his mother's condition, not as payment.
I'm not understanding your question, Justice. Kindly repeat that for me, please.
The suggestion. Yeah. Do you want to just paraphrase
Yes.
what?
So I think that the point is really this: there's a difference between him claiming the profits and him claiming compensation because of his mother's condition.
In this case, he is claiming the profits that were generated from the Hlela cell line. And the reason why we stipulate that he's entitled to the profits, as my learned colleague brought, is because he is the beneficiary of Ms. Langa. And as a result, because Ms. Langa retained ownership in her human biological material, the consequence that flows from that ownership is being entitled to the profits that are generated from the product that is developed from that research, which is the Hlela cell line. In terms of Section 60, subsection 4, which our learned colleagues bring forth as being relevant, which stipulates that it is an offense for any person who donates blood or tissue.
Ms. Swana, can I just interrupt you? I don't think as fast as you speak.
Sorry.
It's an advocate thing. Can I ask you just to slow down so I can follow you more clearly?
Sure.
Because you made an interesting point just now, but I lost you somewhere.
Sure.
Take a deep breath.
In terms of Section 60, subsection 4, which our learned colleagues bring up as being relevant to this discussion, stipulates that it is an offense for a person to be compensated for their donation in blood or tissue, except for costs that were reasonably incurred by that individual. And we have 4 responses as to why this does not apply in this specific case. The first reason being, in the very same article that our learned colleagues bring this discussion in point, the article stipulates that tissue does not include material such as cell lines, and by virtue of this statement means that cell lines are not included in Section 60, subsection 4. And the conclusion there being it isn't an offense for Ms. Langa, subsequently...
That's a very technical argument. Is tissue not comprised of cells?
Yes, ma'am.
So what's the difference?
Failing which, Justice, if the court isn't with us on this issue, we would then say that the principles of the ordinary contract of sale would kick in at this point, which require there to be two things. One, consensus between the parties, and two, intention to sell and intention to buy. And the requisite intention was not present in this particular case. Ms. Langa did not intend to give her human biological material in exchange for money. The benefit that accrued afterwards, and she wasn't in contemplation of the benefit actually accruing.
So she didn't contemplate that. Why should her son derive any part of the profit?
By virtue of the fact that, one, she is the owner of the human biological material, and as a result, any benefit that accrues from that project that the...
What if the university, I'll ask the other side, what if the university, the medical school, has thrown the tissue away? Could the son say, look, you didn't use it to make profit, you had no business to throw it away, my mother was the owner, you should have returned it to her, and after she died, you should have called me to come and collect the tissue?
What the University of Empangeni, if I'm understanding your question correctly, Justice, would do after with that tissue would be dependent on the agreement that they've had with the research participant while she was still alive. And this would include working on it for
Okay, you have 2 more minutes. The court is being, my colleagues are being more generous than I would have been.
What is our stance in terms of benefit sharing? Our stance is as follows, that Mr. Langa, by virtue of being the beneficiary of Ms. Langa, who retained ownership in her human biological material, is entitled to all the profits generated from the cell line. If it was a case of them agreeing on the profiting off of the results of the product, then they would share in the profits. However, because the University of Empangeni decided to intentionally remove Ms. Langa and her family from the decision-making, intended to exploit her family, and as a result, he is entitled to all the profits generated from the cell line. We plead with the court to dismiss this appeal in light of the principles of equity, of justice, and of maintaining the right of dignity of research participants in South Africa. Thank you.
Thank you very, very much indeed. Now I want to remind the applicant side that all they have is a right of reply. Don't raise new matter. You need only talk about and respond to matters that have been raised by them, which you haven't dealt with. You're not getting a fresh bite at the cherry, right? Who's doing the reply?
Thank you, Justice.
Will 5 minutes be enough?
Yes, thank you, Justice.
Right.
Justices, we find fault with our learned friends' reliance on Section 64 of the Act as a means by which the appellant was not a bona fide possessor. We submit that the cell line falls within the specified grounds for donations, being health research, therapeutic purposes, or advancements of health science, specifically the latter. It's clear from the Henrietta Lacks case that a cell line is used, as I have said in my previous submission, for numerous purposes relating to health research, and specifically advancements of health science. We therefore submit that the respondent's reliance that the appellant was not a bona fide possessor and therefore specificatio cannot stand is flawed on the fact that it did fall within Section 64 of the legislation, and it therefore adhered to these purposes. I will now move on to the submission made by our learned friends in respect of the donation, the prohibition on benefit sharing for donations. They have said that that does not cover derivatives of tissues, such as cell lines. However, the legislation is very clear that where a donor donated tissue, they have no right to the benefits or the profits arising therefrom. The deceased did not donate a cell line. She donated tissue. She signed giving away a biopsy for the purposes of diagnostics as well as research. We therefore do not agree with our learned friend submissions that the prohibition on benefit sharing should suddenly fall away because a cell line emerged from the tissues. The tissue was the subject of the donation. Thirdly, we implore the court to apply the law as it stands. If this honourable court were to find that section 60 subsection 4 does not apply in this case, we fear that this may set a dangerous precedent for future cases relating to human biological material, and as we have stated, the commodification of the human body. Finally, we submit that the order, or the judgment rather, of the Court of Quo awarding all profits is patently unfair. Surely, and we concede, perhaps a lesser portion of that could be given were this honourable court to find that none of our submissions.
The poor university.
Thank you, Justice. The term relied upon is benefit sharing. The term sharing is clearly not being practiced if the deceased's family were awarded all the profits.
Ms. Leader, you're not conceding your learned opponent's point about equity.
No, Justice. I'm simply saying that if, as an alternative, if this court were to find that none of the submissions we have made today meet the standard of this court, that still the judgment of the Court of Quo cannot stand. It is awarding 100% of the profits, derived through intense research, through intense scientific inquiry, through funding for the process of extracting cell tissue.
But now, is there anything really burning you what you need to say? Are you done?
Thank you, Justice. I'm done.
Particularly based on the Constitution.
Yeah, the Constitutional Court is not going to be happy with you, but let's just leave that aside for the moment.
We submit, Justices, that if we were to look at a balancing of human rights, we bring into the arena Section 36, the limitations clause. Were the respondents to rely on human rights as I believe they have, then we maintain that Section 36 should allow for the reasonable and justifiable limitation of those rights, as the prohibition on benefit sharing serves a legitimate government purpose, the non-commodification of human bodies and non-exploitation of vulnerable persons. Thank you, Justices. That is our submission.
We're now in your hands, Mr. Registrar. I take it that you're going to require us to adjourn. For how long? Could you tell us?
Justice, that will be up to you.
All right. We'll come back as soon as we can. And thank you very much for your helpful argument. We are now adjourned because we can say that whereas it is just to do so, therefore this court will now adjourn.
Rise in court. May be seated.
Thank you.
Ladies and gentlemen, please could you find your seats? Rise in court.
Registrar, thank you. Do you think we can now begin?
Yes, my lord, you can.
All right, so I think that the justice on my right-hand side will start the proceedings.
This is the wonderful part of the evening where you receive our feedback. I have to hand it to all four of you because you were faced with a very difficult and at times emotive subject. You all handled it very well, not clinically, and showed the right amount of Ubuntu in your arguments, all of you. So well done on that. We were enjoying engaging with you, and at times it may have seemed too much in directing questions at you, but you all faced them very well. Ms. Zondi, you were our first victim, but you held your fortitude very well, which is good, and you directed us back to your argument. I think all of you did. Ms. Lead, you, by then, I could see you were a bit more settled in by the time Ms. Zondi, her experience was over. And even so, what I enjoyed about the two of you was the synergy you had. You worked very well, you communicated, and it was evident that you had prepared and were arguing as a team. Before my brother on my left scolds me for taking too much time, I'm going to turn to your colleagues for the respondents. Here too, you knew your papers well, and that's always excellent. Preparation is good. You, of course, had the more emotive side to argue, but I appreciated that you brought us back to the facts and to the legislation, the guidelines as well, just helped to clarify all of that, because there was a lot that we needed to process. The tip I always give, I'm not an advocacy trainer, but the tip I always give is a tip that is something, a practice that I myself use, which is just take a deep breath. Take a deep breath, calm yourself down. Remember, watch your presiding officer or officers, watch that they're with you on your point. Don't rush ahead because, like I said to you, your passion, I think, was taking over, and your knowledge of the material was taking over, and you wanted to get your point across. But remember, we're trying to follow your trend of thinking, all of you. But I'd like to say very well done to everybody. It was really a very enjoyable experience for me, and I hope now that it's behind you, someday you'll turn around and think of it as enjoyable as well. Thank you.
Thank you very much. Those were Thank you. Those were very useful remarks, and I think that a little applause is called for, not for the speaker, but for all of you as well. Right, from the colleague on my right to my colleague on my left.
Thank you. Again, congratulations to all of you. You argued very well, I think, considering the pressure you were under. Fortunately, I think the case was fairly evenly balanced between you, and it could have gone either way. And you did make the most of identifying the relevant facts. You then had to look at the issues, and I think you did that as well as could be expected as well. Particularly the whole argument about not selling tissue and who owned it, and those sort of issues as well. And then also looking broader at the Constitution. Some of you didn't have quite enough time to dwell on the Constitution, but the whole question of locus standi, I guess, really, whether the son had that right or not, you had to deal with it. And we thought when you did deal with these things, you both dealt with them very well. So I think both counsel, you've got to both be congratulated on what you've done, and you too as well, because it was evenly balanced. You knew occasionally, remember that we're not always trying to catch you out. Sometimes the judges are just trying to clarify a point, and if it's in your favor, take it and run with it, because that can be to your advantage as well. And you can get an idea if you read the way the court's going, you get an idea as to which way things are going with them. But again, I think this is probably a baptism of fire for some of you, and particularly the first counsel always gets nailed to start off with, and the same on the other side. The lead counsel get it, but the junior counsel really stuck. You guys really got in and supported very well. So congratulations to all of you. Well done.
Yeah. Thank you very much. My colleagues have said much of what I wanted to say, and thank you very much to them, which means that mercifully, I don't have to speak for too long. But I want to say that there were 3 or 4 things I want to say. The first is, don't concede things too easily, because think carefully, because many judges are bullies. And they ask you to concede something, and you've got to think very carefully before you concede. It is better sometimes not to answer a question too quickly. But also, beware the Trojan horse. Because if you are given something, and if somebody says you are right, there may be some very hidden thing in there which you will have to worry about a little bit later. So be very, very wary. The next thing is, and you didn't have the time to do that, this will happen ordinarily when you're in a court, you have got to understand the mind of the person you're talking to if you're arguing a case. You've got to understand the judge, you've got to understand the weaknesses, you've got to read their judgments properly beforehand and work it out so that you can get through to the judge. And there, all of you were very good, because all of you started by reading. But once interaction began, I could see almost all of you measuring us. And once you measured us, you knew how far you could go. And that's why, in a way, the person who argued first, absolutely the first, was the most disadvantageous of them all. Because the person who argued second knew exactly what was going to happen. And one of the ways to do it is to make sure that some kind of balance is achieved at that level. But you must always make sure that the person who argues first, you must know, generally has a much more difficult chance. But over and above that, it was very, very hard for us to decide the winners. It would have been so easy if we could have given prizes to both teams, given certificates to everybody to say everybody won. But unfortunately, life doesn't work like that. We had to make a decision. We had to make the decision in the requisite time. But congratulations. Thank you very much, all of you, and to the university for giving us the opportunity. We are very proud that our future society, when we are no longer around, is going to be in the hands of courageous, wonderful people like you. So thank you very much. Now I think we move over, Mr. Registrar, to the prize giving. That time has come.
So the decision has not been presented as to the outcome?
No.
Will that be presented at a later stage? All right, so we're going to call Professor Friedman up to help us with the ceremony, and we're going to keep the tension just a little bit longer, ladies. Council, this is not Idols, it's not South Africa's Got Talent. It should be, but it'll be announced very soon. All right, so we're going to award the semi-finalist certificates first. May I call on Ms. Tanatswa Chinyanga to receive her certificates. Thank you. And we're going to ask an advocate, Mahabir, to award these, please. Thank you. Next, may we call on Ms. Chloe Lead. Ms. Sabahle Zondi. Ms. Lumka Swana. Ms. Calliope Geldenhuys. Ms. Wandiswa Twili. And Mr. Azande Qele. And if at this juncture I may also mention that Ms. Calliope Geldenhuys and Mr. Azande Qele represented the School of Law at the Child Law Moot in Pretoria and did very well. Now we're going to call on Professor David McCoy-Mason to please present the certificates to the finalists. And I see trophies. Lovely. First, may we call on Ms. Tanatswa Chinyanga. Then Ms. Chloe Lead. Ms. Sabahle Zondi. and Ms. Lumka Swana. Thank you very much. At this juncture, we'll call upon Justice Zach Yacoub to announce the winning team and winner and present the trophies. Thank you. Pardon? Sure, we can ask Professor McQuaid-Mason to join the judges, please. Is there a loose one available? No. All right, so...
In the matter between the University of Empangeni and Andile Langa, the court finds in favor of the appellant. The court finds that the Moot Court competition winner for 2023 is Ms. Swana.
Thank you very much, judges. Thank you. Yes. At this juncture, we are very happy to show our thanks, benefit sharing with our judges, and I'll call on Professor Friedman to assist us. Thank you. All right, so to Justice Mahabir, thank you. To Justice Yaqub, thank you.
Thank you very much. That's fine. Thank you.
And to Justice McCoy Mason. All right. Now I know I'm between you and your refreshments, so I'll ask the judges to just remain for a few more minutes while we do the acknowledgements, and then we shall adjourn. Thank you.
Thank you.
You want to stay here?
Whatever they'd like to do.
What do they say?
Whatever you'd like to do. Would you like
Let's
to
go
remain?
down. Let's go.
Yeah.
Go down.
What do you think, sir? What do you think? Let's just stay
Can
still.
you
Let's
go
just
down?
Absolutely.
Okay, stay here.
stay here.
Stay here.
Okay. All right, so I will be very quick then. Acknowledgements. The School of Law is extremely grateful for all of those whose efforts have contributed to the success of this evening. They include Juta and Company and LexisNexis for their sponsorship of gifts for the Moot Court judges and the finalists. The finals of the Ellie Newman Memorial Moot Court were judged by Honourable Justice Zach Yaqub, Professor David McQuaid-Mason, and Advocate Sandhya Mahabir. The topics for the finals were drafted by a committee comprising of Professor Donrich Theldar, Professor Managay Reddy, and Mr. Christopher Gievers. The semi-finals of the Newman Moot Court were judged by Professor Freddie Myongani, Dr. Janine Hicks, Ms. Nomfundo Mtembu, and Ms. Masiwe Ngumalo. The following advocates who graciously agreed to assist in providing advocacy mentoring to the Moot finalists appearing tonight, Advocate Elad Mizrachi and Advocate Kumbu Shazi. The Registrar of the Moot Court tonight, Mr. Azande Bongali Trele, with a beautiful voice. Our timekeepers, Ms. Calliope Ann Geldenhuis and Ms. Wandiswa Dwili. Thank you. The GTAs, those are the graduate teaching assistants that assisted Notando Ngobo, Nolutando Makoba, Simihlile Zulu, and Banele Nkosi, who assisted in setting up the venue and providing assistance through the evening tonight. Then our service providers, the various support teams within the university, including ICS, RMS, and corporate relations. The Ellie Newman Memorial Moot Court Organizing Committee, Mr. Matthew Kimball, Ms. Razia Ahmad, Ms. Hazel Langa, Ms. Caroline Nasia, Ms. Fikile Mkwanazi, Ms. Kabita Maharaj, Ms. Veronica Peter, Ms. Gita Jagru, Mr. Nkosikona Zulu, and Mr. Pradeep Ramsawak. It is my pleasure to bid you adieu, good night, hambagatle, take care, travel safely, and for those in person, please join us for refreshments. Finalists and the staff and invited guests, please join us in Suite C upstairs, and the students, the rotunda is at your disposal. Siyabonga kakhulu. Thank you.